Good morning. This is the Energy and Carbon Management Commission for the state of Colorado. It is Tuesday, April 7th, 9 a.m. We have an agenda before us. We start with a roll call.
Thank you. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
and Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
All right, very good. We have one docket before us today, docket 2505-00076, an oil and gas development plan proposed by the applicant GMT Exploration. It's called the Gorge OGDP. We also have received information that is subject to the executive session rules. So what we're going to do is we're going to swear in the witnesses, recognize the applicant, and then go into executive session to hear from the applicant on business privilege materials. Ms. Jones, does that sound fair?
Yes, Chair. Good morning and thank you. That sounds great.
If you want to elevate your witnesses, please, or if the witnesses want to visualize themselves.
Yes, thank you so much. I see them still coming in. Let's see, we've got Max. We need Hans Schuster. And we'll also need BJ Cox.
Jamie, can you not see me?
Yeah, we can see you, Mr. Schuster.
Okay,
Yes.
great.
It looks like we just need BJ Cox and then Brad Davis. I guess GMT team, is Brad going to join Tom, or are you covering for both?
No, Brad had a personal matter he has to attend to this morning,
Okay.
so I'll be filling in for him.
Okay, wonderful. So once we have Mr. Cox on, then we should be good to go. Or Mr. Boudreau, we've got most of them right now.
Go ahead, Mr. Boudreau.
Thank you, Mr. Chair. I'll ask the witnesses to each be visualized. When I call your name, please raise your hand, state your first and last name, and swear to tell the truth. Max Blair,
My name is Maxwell Blair. I swear to tell the truth.
Andrea Gross,
My name is Andrea Gross, and I swear to tell the truth.
Hans Schuster,
My name is Hans Schuster, and I swear to tell the truth.
Tom Loveland,
My name is LaFell Thomas Loveland, and I swear to tell the truth.
Randy Frederick,
My name is Randy Frederick, and I swear to tell the truth.
and then I think we're still waiting on Mr. Cox.
Yes, apologies. We're still waiting for Mr. Cox to accept the elevation. So one more moment.
And if it helps, Mr. Cox is not going to be speaking directly today unless there's questions from the commissioners. He's a subject matter expert on the panel. Mr. Blair and Mr. Schuster and I will be addressing the confidential business information. So I don't want to hold us up too long for that.
All right, with that being the case, let's move forward. Mr. Boudreau, I would recognize you to help us with the executive session movement.
Thank you, Mr. Chair. Pursuant to open meetings law, the commission is entitled to enter into executive session at this regular meeting to receive confidential commercial data pursuant to Colorado Revised Statutes 2472-204-3A4, as authorized by Colorado Revised Statutes 24-6-402-3A3. Specifically, the commission will receive confidential commercial data regarding the GMT Gorge OGDP, ECMC docket number 250500076. Mr. Chair, you can entertain a motion to enter executive session for the matters I just described.
All right, before we do that, let's swear in Mr. Cox as he's with the panel now.
Hi, Mr. Cox. Would you please unmute and raise your hand, state your first and last name, and swear to tell the truth?
BJ Cox, and I swear to tell the truth.
Thank you.
All right, I would move that we enter into executive session for the purposes as stated by AAG Boudreau.
Second.
Motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? That motion carries unanimously. All right, for the folks that are listening in, there's 37 of you. We will leave this meeting and go into a Zoom meeting for purposes of doing the executive session work. We will take no actions in that meeting, and after we're done with executive session, we will return to this meeting for further deliberations. and or action on the docket. I don't know how long this is going to take. I would guesstimate maybe an hour or so, but that's just a guess. We'll return as quickly as we can. We'll do no further action at this point. Commissioners, I would encourage you to leave this meeting and move to the executive session. Right, I believe the commissioners are back. This is the Energy and Carbon Management Commission. It is 10:30, and we just concluded executive session. I would ask AAG Boudreau to help us out with next steps.
Thank you, Mr. Chair. To get us out of executive session, I'll say we are returning from executive session. During the executive session, the commission received confidential commercial data pursuant to Colorado Revised Statutes 2472-204-3A4, as authorized by Colorado Revised Statutes 246402-3A3. Specifically, the commission received confidential commercial data regarding the GMT Gorge OGDP, ECMC docket number 250-500-076. No deliberations were held, no votes were taken, and no decisions were made. Mr. Chair, you can entertain a motion to exit executive session.
So entertained. Do we have a motion to exit executive session?
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? All right, the motion carries. All right, at this time, we are taking up docket 250500076, the Gorge OGDP. Ms. Jones, do you have anything further before we move into deliberations?
Thank you, Chair. Nothing more than GMT requests approval of the Gorge OGDP application as submitted and with the additional confidential information that was just discussed in the executive session. Thank you so much.
All right. With that, commissioners, Commissioner Oath.
Thanks, Mr. Chair. And I apologize. But before we move into deliberations, I just have two quick questions that were not covered by as confidential data.
Go ahead.
These should be fairly quick. Thank you. Thanks. The first one is of the BMPs that are noted in the supplemental practicability assessment, are these things that are voluntary and over and above regulatory requirements, or are all of these items that are noted required by regulation?
Ms. Jost?
Yes, thank you, Chair. Mr. Blair or Ms. Gross, would you like to take that question?
I will, I may ask Ms. Gross to assist with this, but I'm not sure which BMP specifically you're referring to. I think some are certain. I think all of them are already documented within the Form 2A through the OGDP process, the staff review, and ultimately the direct recommendation. I don't think there's anything new in the PA that wasn't already part of the record.
Okay.
Commissioner Oath, I would say, and Mr. Blair and Ms. Gross, correct me if I'm wrong here, but there were additional BMPs requested by CPW, and those would be specific CPW that are over and above as required in the rules.
Okay, great. Thank you. I appreciate that. Okay, and then the last one is I know we discussed that there are 6 wells proposed in the first occupation at the North Rim, but can you tell me how long those horizontal wells are?
Yes, I can address that, Commissioner. The project is designed for the laterals to be approximately 2.5 miles in length. These surface locations are situated roughly in the center of the drilling and spacing unit, and we are essentially reaching 2.5 miles in each direction from each surface location.
Okay, thank you.
All right, further questions before we move to deliberations? All right, seeing none, we'll move to deliberations. Who would like to initiate deliberations? Commissioner Oath?
Thanks, Mr. Chair. I will be happy to kick us off here, and certainly want to express some appreciation for all of us working through this process and knowing that this application was initially submitted fairly quickly after these rules took effect, and that a good amount of time has passed. So appreciate that we've had an opportunity to have some supplemental information on the record for us to better evaluate the provisions around practicability in these ESPs. I also think it's important to recognize that there are a lot of good things about this application, including that there are no RBUs in close proximity, and also that the applicant has narrowed the ESPs that they are seeking exception for. Noting that Rule 316 does require the use of an electric drill rig. I would just want to put us in the context that this rule is really an important piece of our commitment and obligation to address ozone non-attainment. And I appreciate that, the nearest RBU is over 1 mile away from the North Rim location. And that has many advantages in reducing risk to human health from localized pollutants. However, the primary purpose of this ESP is related to ozone, which is a regional issue rather than a localized one. So I think for me, the distance of RBUs, while certainly extremely important and something that is appreciated here, does not, in my mind, offset or mitigate noncompliance with this particular ESP. I'm also mindful that despite the fact that less wells and less OGDPs were approved in the past year, we are seeing an increase in the amount of planned air emissions per well for VOCs and NOx, which are the ozone precursors. This seems to be in relation to the fact that we're seeing longer horizontal wells, which require more drilling time and are a large factor in this. And in this case, we're talking about 2.5 mile long laterals. And we are anticipating a particularly hot and dry ozone season. So I think the importance of complying with rules intended to mitigate ozone precursors, while always critical, seems even more so this summer, which is when this operator is requesting the application of an exception. That said, our rules do have an off-ramp to compliance with this regulatory obligation for cases where compliance is not practicable. I appreciate the supplemental information that was provided, and I certainly aim to take a reasonable and balanced approach to the operational realities and challenges that exist, while also applying our rules to the best of my abilities and as I understand to have been our intent at the time that they were adopted. There are contractual obligations that have been raised by the applicant, and the applicant has argued that combined with the current unavailability of line power and the uncertainty as to a date certain when line power will be provided, that those create a situation of impracticability. So first, the availability of line power. There has been testimony and information on the record that there is sufficient power for production, and that there is a need to lay 5.3 miles of distribution lines and conduct upgrades to a substation. So it is not an availability issue, but a timing issue. And so I think that's where the contractual elements come into play. So first, in terms of the lease agreement, I do not find that the terms of the lease agreement create a situation of impracticability. And indeed, the applicant itself, I believe, has indicated that the lease agreement is not the driving factor. But the applicant has indicated that the terms of the development agreement are the driving factor. And I would say I do find that a situation that would drive noncompliance with certain of those terms would result in the development at this site to be untenable. And therefore, I do find the terms of the development agreement to be a really important factor in my thinking here. However, based on the information that was provided to us, I continue to remain unconvinced that compliance with the rule that requires the use of an electric drilling rig if drilling is to occur during the ozone season is not practicable. I see a pathway for the applicant to stay in compliance with the terms of the development agreement while still honoring the HPH winter timing restrictions and not drilling inside of the ozone season. And so I do think that availability of a drilling rig could be a driving factor in evaluating practicability and was a factor that I believe we had in mind at the time that this rule was adopted. However, in my mind, we contemplated that if an operator provided information and testimony that they had sought to obtain an electric drilling rig, but that none were commercially available due to supply constraints, that may be the type of situation that would drive a determination of impracticability. And that information was not provided here, and I do not find the testimony that the operator has already contracted for a non-electric drilling rig at a date during the ozone season to be compelling to find that compliance is not practicable. So given that, Mr. Chair, I am not going to be able to vote in favor of approval of this application.
Thank you, Commissioner Oath, for leading us off. Other commissioners with deliberative thoughts? Commissioner Messer?
Thank you, Commissioner Oath, for leading us off. I too find a number of elements of this application to be to meet the rules and the obligations of the Act, and so ultimately this does come down to application of Rule 316, and this is a newer rule. But the rule was developed with clear direction from the legislation that required us to undertake rulemaking around enhanced systems and practices and cumulative impacts. And so in reviewing this, ultimately the question I asked myself, is it possible to comply with the rule? And in looking at the statement of basis and purpose on page 41, it indicates that in Rule 316, the Commission adopted rules governing oil and gas operations in the ozone non-attainment area. The Commission determined that organizing the ozone non-attainment area operational requirements in one rule would provide more clarity for stakeholders. Rule 316 complements the significant additions to the Commission's analysis of cumulative impacts and further reflects the Commission's statutory directive in Senate Bill 24-229 to adopt rules that require enhanced systems and practices to avoid, minimize, and mitigate emissions of ozone precursors from operations at newly permitted oil and gas locations in the ozone non-attainment area. That's CRS 3460-106-11C3. Rule 316 ensures continued progress in achieving the governor's goals that CDPHE and the Commission adopt rules to reduce NOx emissions from the upstream oil and gas operations by 30% in 2025 and 50% by 2030, consistent with House Bill 23-1294's emphasis on the need to address the impact of oil and gas operations on Colorado's ozone problem, and specifically cumulative impacts on disproportionately impacted communities. Rule 316 represents the Commission's acknowledgement and reliance on CDPHE's significant work to date to address ozone precursor emissions from oil and gas operation. The Commission intends for Rule 316 to complement rather than duplicate the CDPHE's NOx intensity target rules adopted by the AQCC. Similarly, the enhanced systems and practices set forth in Rule 316C represent a collaborative effort amongst the Commission, CDPHE, and stakeholders to consider the efficacy of current best management practices and to adopt an initial list that will be reevaluated periodically to account for evolving design, operational procedures, and technologies. Overall, the Commission intends for Rule 316 to both demonstrate and foster more collaboration, cooperation, and consultation between the Commission staff and APCD, a goal the Commission recognizes and important to stakeholders in both agencies. And so in reviewing that and the rules and the applicability and the possibility of complying with the enhanced systems and practices, which are a requirement of our rules and a pretty bright line requirement, understanding that there's the ability for a practicability assessment to be developed to address certain items that are simply impracticable, and I don't think that the practicability assessment was designed to just be an easy off-ramp, but rather an exception, for extraordinarily difficult situations that make it impracticable. And I would agree with Commissioner Oath that this situation that's presented here is a situation of timing more than it is of whether or not it is possible to adhere to the requirements of Rule 316 and the enhanced systems and practices. The timing is a preference in many circumstances. It's decisions that get made, whether those are contractual decisions, development agreement decisions. They're timing decisions that are determined. What ultimately is in the control of the operator is whether or not to enter into those agreements or the timing of those agreements, taking into consideration the whole of the regulatory requirements that are required here. And so I do think that it does hinge ultimately on the development agreement here. And the decision of whether or not to choose to do drilling and completion activities during the ozone non-attainment area and comply with the requirements associated with that, or choosing to do drilling and completions outside of the non-ozone attainment season, and therefore only having to adhere to lesser requirements during that time. I also acknowledge the challenge here of also needing to comply with the high priority habitat and wildlife timing stipulations, and that it does create a narrower windows for the ability to utilize certain technologies at certain times. It doesn't preclude those different technologies to be able to be implemented at different times, but it narrows the window in which lesser technologies may be able to be utilized. And so it certainly is a complex puzzle, but it's a complex puzzle that was handed to the commission by the legislators. And these are the rules that were promulgated by that direction in order to meet the requirements of statute. And so I am struggling to find that the operator is unable to comply with the enhanced systems and practices rules that were implemented. And so I think that they've made an argument on practicability on 3 different items. One item is the produced water enhanced systems and practices. I do find that they made a compelling argument on the produced water elements, and find that it is impracticable in that situation. I think the production equipment and the electrification of the production equipment, I think that also becomes a timing issue, and less of a contractual or development agreement issue. And I'm not sure that they've met their burden to determine that it is impracticable for the electrification of the production equipment on grid power. And then the third one is the arguments made in the practicability assessment on the drill rigs and the decision to either utilize an electric drill rig inside of the ozone non-attainment area, or Tier 4 or equivalent outside of the ozone non-attainment area. And I'm struggling from a timing perspective to find that it is not possible or practicable to be able to meet the rule requirements with scheduling and structuring timelines to be able to meet that. So I don't know, as I haven't made a determination yet, but I'm interested to hear the other commissioners' thoughts on it. And so, but that's where my deliberations are going at this point.
Thank you, Commissioner Messner, for your thoughts as well. Commissioner Ackerman?
Thank you, and I appreciate the thoughts of my fellow commissioners, and I appreciate the follow-up work and the additional hearing that we're having here today. In my view, that follow-up work and additional hearing was necessary to further consider this application. I think I wanted to make a couple points about the practicability assessment. Our intent for the enhanced systems and practices rules during the cumulative impacts and enhanced systems and practices rulemaking was to press for significantly reduced emissions in the ozone non-attainment area, as Commissioner Oath recognized. And I want to recognize that this was a hard press. It was a hard press intentionally, as it is the responsible right thing to do and is in compliance with our statutory charge and the requirements of Senate Bill 181. And that press itself demonstrates one aspect of why our rules are the most protective. But because this was a hard press, we allowed for some off-ramp space through objective analysis and subjective commission judgment through this practicability assessment process with specific requirements and limits as have been detailed by Commissioners Oath and Messner. And really the overall intent of this approach is really to do everything we can within operational limits to, in all diligence, reduce ozone emissions in the ozone non-attainment area. So to me, a detailed and complete practicability assessment rather than a cursory compliance with or lack thereof with the regulations for compliance sake alone, it isn't really helpful. Its intent is to truly help us understand the actual practicability of the associated operational restrictions versus the most reasonable enhanced systems and practices that are detailed in the rules. And then that should result in a thorough objective analysis on which we, the commission, can base our subjective judgment as to whether this particular off-ramp is allowable. So, it's kind of similar to the deliberative process used with variance requests. And really, this is why we have these hearings. And we don't simply use some kind of a dichotomous key to just administratively approve applications. There is subjectivity intended in this regulation and off-ramp. I think some points of diligence that are favorable to the operator here are, I first wanted to acknowledge the COA discussed at the first hearing requiring CPW follow-up to ensure CPW's concurrence with the operator's approach, as there were some discrepancies between the operator's presentation and the consultation materials from CPW. I think that COA that we talked about in the first hearing allays any concerns that I raised regarding CPW consultation. Something that comes to mind for me when I look at this kind of situation is what was the operator's level of diligence regarding coordination with the utility company, as we're requiring grid hookups here in an area that admittedly doesn't have grid hookups in many places that are targeted for drilling. In this case, there was significant negotiation demonstrated, some significant planning demonstrated. I think there was significant good faith for compliance demonstrated here with a prepayment for grid connections and necessary upgrades, as was testified to in the materials in the previous hearing as well. To me, that application with the additional practicability assessment information demonstrates adequately diligent ongoing work with the power provider that provides to me some level of faith and trust that it will lead to an appropriate transition of production equipment to the grid, as well as recognition that it imposes a hard stop on future drilling beyond 6 wells until grid power is established. I think that's a reasonable approach in an area where grid power doesn't exist. I also think there was some timeline diligence. While I agree with Commissioners Messner and Oath that there's a complex timeline associated with this, and I'm very sensitive to self-imposed conundrums. I do think there was some timeline diligence here, and there has been a pretty diligent effort to work within scheduling margins when considering and complying with significant but relatively standard contractual obligations held by this operator while still honoring HPH timing restrictions. And I would note that while contractual obligations are certainly not within our purview or our control, I do recognize that the industry operates within a competitive environment and that contractual obligations do exist out of nature. If those obligations, to me, don't fall significantly outside of industry standards, it's reasonable to consider some of those limitations in a limited scope, certainly in a development plan scope, within the context of a practicability assessment. I think there's a limited exception request here, and that also is helpful for me. It's narrow, it's time limited, it's directly tied to the enhanced systems and practices that are outside GMT's control, i.e. the timing of the electrification of the facility. If approved, this would result in 6 of 24 total wells drilled under an electrification exemption. So that's 25% of the total wells of this development. And I would note that they've proposed a development plan that is, from my understanding, within the compliance of CDPHE rules. So the points that have been raised so far in these deliberations are good ones. I think that, as we kind of strive towards what really helps in a practicability assessment, to include objectively, in order for us to subjectively debate whether or not this meets the standard of which we intended when we allowed for this off ramp, is a bit of an iterative process and ongoing. I recognize that. I think to the points Commissioner Messner made about produced water, I would agree. I think practicability was set forth, and particularly with regard to the potential impacts of the construction of a 35-mile pipeline, as opposed to the impacts of removing produced water via truck, was an acceptable practicability assessment demonstration. I am a little hung up on timing here, and I've been trying from the beginning to determine whether this is significantly self-imposed timing and an attempt to try to move through some self-imposed timing problems, or whether this was a diligent contractual effort, a diligent application, a diligent development effort that has some contractual timing difficulties associated with it. I'm convinced that it's the latter. I think that in the end, I think we can get there. I still am very interested in maybe hearing a little more discussion about Commissioner Oath's point of, is there a pathway to contract a grid-powered rig in a way that doesn't impact the ozone non-attainment timing restrictions? I get that that's tight. I understand that. I do think it deserves further development and discussion, as again, the intent of the rules is to, in all ways, be able to avoid the exception, if at all practicable and possible. And that point remains a little unanswered to me. But other than that, I do think that we're moving towards, in my opinion, an application that could be provable and has demonstrated sufficient diligence, both in grid connection and the other tenets of the practicability assessment.
Thank you, Commissioner Ackerman, for your deliberative thoughts. Commissioner Cross, do you want to go next, or do you want me to? Are you still with us?
I am still with you. I apologize.
Hey, for the record, Commissioner Cross feels like shit. So he was up all night. So I really appreciate your dedication staying with us.
I appreciate that, Chair, and I'll just be brief with my comments. I do agree with what Commissioner Ackerman said. I'll say I thought the initial application left something to be desired. I appreciate the supplemental information that was provided that gave more detail when it came to the practicability assessment. Ultimately, what it comes down to for me is while I agree with Commissioner Oath that this is a timing issue as opposed to more so a possibility issue, I do agree that I think there has been diligence done by the operator to make sure that to try and get everything done in time, that everything being drilling completions before the high priority habitat timing stipulations apply. You're going to have to get started before the ozone non-attainment season ends. And this is purely with respect to the fact that they have to show paying quantities on their lease. And so I think the fact that they have lease obligations that they have to attend to, while a timing issue is different than an Excel or United Power or somebody else saying we can't get power to you, and that's why it's impractical. We do see here that they've taken the steps to talk to Excel. Excel is going to bring the power out to them. They just can't guarantee it getting done by the time that they have to drill under their contractual obligations, and trying to move outside of the ozone non-attainment season to make sure that they can get that done creates additional risks, whether it be contractual with meeting the lease obligations or contractual risks when it comes to getting the drill rig. And so I do think that the initial application left something to be desired. I'd love to see more detail on exactly why certain things are proposed, why timelines are proposed without us having to kind of pull it out of the operators. But I do agree with Commissioner Ackerman that I do think that there was due diligence done for this, and I do see it being impractical for the first occupation. And as Commissioner Ackerman noted, I do think it's important that there will be electrification of production, electrification of drilling for future occupations, including the 6 initial wells being drilled. And so the fact that they are trying to make sure that that's set up while still meeting their lease obligations is noteworthy to me.
Thank you, Commissioner Cross, for your deliberative thoughts as well. I too can be somewhat brief. I find all 4 commissioner staff made really valid comments. I find that that the applicant has done its due diligence in terms of providing to us a practicability assessment that gets me in a place that is similar to Commissioner Ackerman and Commissioner Cross, that they've done their due diligence. I think the work with Excel does establish diligence. I agree with some of the things that we learned about in executive session. I also look to the fact that Arapahoe is the local government and they're going to be okay with it. The state land board is in favor. CPW has been taken care of. I think that we are, again, striving to meet the tenets of the enhanced systems and practices, but we also created an off-ramp. I think this is a slight use of the off-ramp. I appreciate the math from Commissioner Ackerman of 25%. And so I guess the other piece, and Commissioner Ackerman, you touched on this, is you were interested in further thinking about or discussing or talking, and I'm not sure if it's with the applicant or amongst ourselves, with the points raised by Commissioner Oath in terms of the timing issue. And so I would probably turn it back to you to see if you wanted to amplify anything further on that point.
Sure, Mr. Chair, thank you. I appreciate that. And in the end, as Commissioner Oath kind of set forth, that we're requiring this enhanced systems and practices absent a proper demonstration of lack of practicability through the practicability assessment. I think the point that Commissioner Oath made about was an attempt made to take a look at that window to the question remains because it hasn't been exposed to us. It hasn't been we haven't had it answered. We don't know whether they've attempted to get an electric rig during that time frame. We don't know if their timing their operational timing constraints can in some way contort within that window. To me, it's just that question hasn't been answered. And so maybe the operator has answers to whether they are able to, maybe they can quickly answer that question. They've done this analysis and determination just wasn't included. Or, maybe we need to have some further discussion about the reasonability of requiring them to do so in an additional step, and whether that's a reasonable approach given this confined practicability assessment discussion or not. To me, that would be kind of fallback one.
Okay, thanks for that. Commissioner Oath.
Thanks. I really appreciate these comments and the kind of openness and interest in kind of exploring if we can find a pathway forward. And I guess just would also make a comment or put it out there for consideration that kind of one of the limitations that we have talked about is high priority HPH winter timing restrictions and the January 1st date being an important factor there. That said, I have seen us discuss that as being a factor that is not a hard and fast deadline, but is something that, we consider in terms of kind of the two very important goals, right? Addressing health and environmental considerations. And here that's kind of drilling during ozone season with wildlife protections. And so, if we're going to explore kind of some operational windows that, whether they're available, I think I would just want to keep an open mind about some options there and not consider January 1st a hard deadline necessarily. That's my thinking. Obviously, it's an important consideration and one we'd all want to be mindful of.
I appreciate that point, Commissioner Oath, and I would echo the point that you just made. I'm not sure where that gets us in terms of where we're going with deliberation, but I appreciate the openness of commissioners to think through this, with the applicant and with our staff. Commissioner Messner?
No, I appreciate the discussion as well, and I think Commissioner Oath, I think that's an excellent point, because I think that there's a number of times when we've actually had consultation with CPW that determined that if operations begin before the timing stipulation and bleed 2-3 weeks into the timing stipulation, as long as it's continuous activity, particularly in the habitat that we're talking about here, that sometimes that may be less impactful than a start outside of it and then start again within the timing stipulation. And so, interesting thought there. That also brings around because full circle my thought that is it possible to comply? And as I think about these things, I think that creates more opportunities for the possibilities to comply with the enhanced systems and practices without the need for a practicability assessment. And so, I think that that is an interesting point that is brought up there. So thank you for bringing that up.
Further thoughts from folks? All right, I might call upon Ms. Jost to see if she has any thoughts. You're seeing the deliberative thoughts from commissioners. I also don't want to call on you cold if you felt like you needed to speak with your client or not. You don't need to say anything either. It's entirely up to you.
Chair, thank you. I would really like to take 10 minutes to speak to my client if we may.
Yeah, then let's do that. Is 10 enough?
If you give me 20, it'd be great.
Let's return at 11:30.
Thank you so much.
All right, this is the Energy and Carbon Management Commission. We are returning to deliberations. Just want to make sure, Commissioner Cross, just give me a thumbs up that you're with us. Make sure we've got a quorum.
I'm with you.
Okay, thanks. All right, we left this last at 11:09 to give the applicant a chance to think through some of the deliberative thoughts. Ms. Jost, do you have anything to provide to the commission?
I do, Chair. Thank you. And we did take serious consideration of the deliberations and the comments from all of the commissioners. And GMT would like to offer a condition of approval. And the condition of approval, this would be an additional condition of approval to the ones we've already offered, that GMT will utilize the Tier 4 drilling rig for the first occupation on the North Rim location and will immediately convert the Tier 4 rig to electric if Excel delivers grid power to the North Rim location during ozone season, so during May 1st to September 30th. That's a COA we'd like to offer, recognizing the restrictions on Excel and getting to the site since there is no time there. But if grid power can be delivered during ozone season, GMT would request that that COA be adopted by the commission, that they will convert the rig immediately to electric. The other thing I wanted to say is that GMT also confirms the prior COA offered by GMT that the second occupation on the North Rim and the first and second occupation on the Black Canyon will utilize an electric rig. Two items of note for this is that it is critically important to GMT that it honor its commitment to CPW to conduct pre-production operations outside of the HPH timing stipulations. And then the other point is that Tier 4 rigs have been approved by this commission as well as CDPHE for drilling in ozone season on multiple occasions by this commission since December 2024. And that's where the basis for our COA offer, Chair, comes from.
Okay, thank you very much.
Thank you.
Commissioners, returning it back to us for additional deliberations. Commissioner Oath.
Thanks, Mr. Chair. I think this probably goes without saying, but a clarifying question for Ms. Jost, if I may.
Please.
Ms. Jost, appreciating the offer of that COA, but should we take that to mean that GMT is not willing to consider a COA that would utilize the Tier 4 engine starting October 1st or after?
Yeah, Commissioner Oath, due to many conversations we had during the executive session, based upon timing requirements, the October 1st is not practicable from GMT's standpoint.
Okay, thanks.
Therefore, rig is necessary during ozone season with, again, the proposed COA that if grid power can be delivered by Excel, they will convert that rig to electric. Thank you.
Okay, thank you.
Thoughts from commissioners? All right. Maybe what we should do is kind of do a sort of a straw poll to see where things exist. Commissioner, I'm just going to go in the order in which commissioners chatted to deliberate. Commissioner Oath, where are you at?
Yeah, sure. Thanks, Mr. Chair. Thanks I just think I needed a few seconds to get my thoughts together. I appreciate all of this discussion. I appreciate GMT making this potential offer. I guess for me, it does not change my assessment of practicability here. And I guess maybe a comment in response to the piece about Tier 4 engines. In terms of ranking, that's a great backup, and that's on the positive side. However, I think saying that they have been approved before is kind of comparing apples to oranges in my mind. That there have only been, I think, a handful of applications that we have reviewed under our new rules that have these requirements, and I don't know how many of those we're proposing drilling within the ozone season. But so I think we're in a bit of a different situation. So I think that's not compelling to me. And I guess the The COA is interesting, I guess, but I think that given the information that the applicant provided about where things are with the utility, it's certainly very unlikely that line power is going to be available during the ozone season. So I don't feel like this gets us anywhere, and certainly doesn't change the fact that I see a different pathway, and it just haven't been we just haven't been presented, I think, with the evidence to find otherwise from my standpoint. So I haven't changed my mind.
Thank you. Commissioner Messner?
Thanks. Again, the reasons I indicated in the SBP and in the rules, I think that Rule 316 is a pretty bright line rule. Ultimately, I'm looking at this, that is it reasonably possible to comply? And I do think that what we're facing here is a self-imposed timing restraint, and financial considerations do seem to be one of the primary drivers. And so I do find that it is reasonably possible to comply, and that it hasn't been fully explored outside of the ozone timing stipulation, utilizing Tier 4 equivalent. And so I'm going to be not able to find that the practicability assessment has met the burden to not have to comply with Rule 316.
Thank you. Commissioner Ackerman, continuing in order here.
Thanks, Mr. Chair. What a treat. Usually due to the name Ackerman, I get to go first, but I appreciate the opportunity to be able to listen to my fellow commissioners and their wisdom. To me, it's no surprise that there's some divergence in thought here due to the intended subjective nature of this analysis based on what's presented. I think there are a lot of good things about this application, as we've repeatedly stated. I think the practicability assessment is an opportunity to demonstrate objectively, to put forth objective information to allow us to weigh whether or not the exception validates reason for the not complying with the rule, and it's a bit of a squishy bar, and again, it's intended to allow us to have this discussion. I think kind of where I'm at is that I mentioned my fallback being a discussion over whether it's reasonable to hold over or deny the application based on the limited information we have. We have received some statements from the applicant as to whether or not they believe that it's practicable to operate outside of the ozone restriction period. They've stated under testimony no, that it's not under their development schedule. They've given, some other evidence in executive session as to what some of those constraints are. And so it kind of hinges to me upon whether or not I think it's reasonable to hold over or deny the application based on that limited information on I don't want to call it hypothetical, but based on a somewhat small window of opportunity to potentially comply with development outside of the ozone and HPH period, or whether we remand it back and reopen that whole discussion as to whether or not we trade off between ozone and wildlife here. And I think that, to me, when we start having that conversation and deliberations, we're starting to kind of venture into the limits of applicability of our rules, right? I think I've rarely seen a perfect application come through. And so then I have to ask myself, do I reasonably believe they're in compliance with the rules and the intent of the practicability assessment? And while not perfect, Mr. Chair, I lean towards this application being in compliance with the intent of the practicability assessment, given the conversation and further exposition that we've had.
Thank you. Commissioner Cross?
Mr. Chair, it looks like we lost Commissioner Cross. I will reach out and see if I can assist.
Okay. Let's give it a second.
Commissioner Cross is back in the room.
I apologize. In addition to not feeling well, my computer decided to restart on me.
Of course. We're going down the line and getting kind of straw poll votes on whether folks find this to be approvable or not, hinged on the practicability assessment. Do you want me to go over my notes in terms of what I've heard so far, or are you just ready to roll and tell us what you're thinking?
I will say I heard the first half or so of what Commissioner Ackerman said, and that's when my computer restarted.
Commissioner Ackerman concluded that he would lean toward this being approvable under the applicable practicability assessment.
Okay. I'll be brief. I think I'm the same way. Again, I want to try and encourage operators to provide as much information as possible when it comes to deadlines, how long things would go. I also had a bit of consternation in trying to say, well, we could comply with ESPs as long as we maybe go over the timing stipulations that CPW provided. And I think that brings up a much larger issue. Yes, we have done it at times, but I think that's also times where CPW has weighed in on that possibility to begin with, which they haven't done here. And, you know, I think just a point for everyone to think about is I think we are going to probably see a lot more situations where it is a question as to prioritizing public health, safety, welfare for people versus prioritizing wildlife. And even though it is something that we're required to regulate in a manner that protects all of those things. So I understand that there could be ways, but trying to fit a square peg into a round hole on possibilities that there may or may not be a rig, and I think it creates a lot of difficulties. And so I do think that there has been impracticability shown. But again, I encourage operators in the future to provide us as much information as possible.
All right. I am very appreciative of the thoughts of Commissioner Oath and Commissioner Messner. However, I lean slightly to the direction of Commissioner Ackerman and Commissioner Cross. I also wonder, before we finalize any of this, if we could, and this is a question for my fellow commissioners. I understand that Wildlife Officer Moret is in the room and could be able to speak. Is that something we would like to hear from at this point before we try to finalize determinations and deliberations? Commissioner Oath, is that just a yes?
Yes.
Commissioner Ackerman?
No objection to hearing what he has to say.
All right. Hearings Manager Thomas, if Mr. Moret is available, could we elevate him?
He is elevated.
Good afternoon, Commissioners. Brandon Moret here.
Yeah.
Not a wildlife officer, but a wildlife biologist.
Sorry, I apologize.
No worries.
It was not meant to be anything other than just me not paying attention. Before you speak, Mr. Moret, I want to give you a chance. There's been a lot of discussion and deliberation, and the last thing I like to do is to put folks such as yourself and sister agencies on the spot. So if you want to just say thank you very much, but I don't have anything to add, that's perfectly acceptable. If you feel comfortable to say something more relevant to the deliberations that we've been talking about, that's fine too. I wanted you to have that flexibility.
For sure, and I appreciate that. And so I think I have a few points that as I've been listening, I've been writing down, and I think the first thing I'll throw out is page 202 of the Statement of Basis and Purpose does say that development can occur in 1202D habitats. Obviously, that is something that I try to make sure is not the rule that happens regularly, but is something that, given other constraints, whether it be ozone, regulatability, landowner preference, that type of thing, like with crops, that does allow us. And based on the testimony that we presented during the rulemaking, there are opportunities for an operator, whether it be GMT or other operators, to provide minimization measures and an increased mitigation amount that can allow for demonstration of avoidance, minimization, mitigation. One such example is sound walls. And so I do not talk about sound walls when an operation is proposed during the non-winter months. But when it gets into the winter months, whether it be a week or a month, that is a time that I do suggest that sound walls is applied to an OGDP like I mentioned, to demonstrate those minimization measures. And so, I ran some quick numbers, and obviously if this operator chose to impact a portion of the beginning of the winter season with continuous operations, that would increase their indirect amounts by about $77,000. So in my wildlife consultation summary, it said about $208,000 for direct and indirect. That would go up to $285,000 approximately to impact a portion of that should they choose that option. So I think I will pause there. And obviously, the starting point with every consultation with CPW in the Northeast region is avoidance of the winter season. But that hasn't been going into the winter season, as you know, has not been a rare case. Shooting from the hip, it's been about 40% of OGDPs. So I think I will stop right there and see if commissioners have any questions.
Commissioners, questions? Thank you very much for being with us, Mr. Moret. Commissioner Oath.
Thanks, Mr. Chair. I have no questions for Mr. Moret, but just wanted to say thank you for being here, being willing to provide that context for us here on the record and on the fly. So thank you. And then I also was thinking, if we're thinking about potential trade-offs and how we think about how to balance protection of wildlife. And so we're getting some thoughts from our sister agency who has expertise in that realm, balanced with public health and environmental protection. And particularly, we're talking about ozone here. And while we have here at ECMC certainly have an important role, we're not the lead agency on ozone protection. And we do have our sister consulting agency at CDPHE with expertise in that area. So I'd be interested in just hearing Ms. Sorensen's thoughts on this as well.
Great. Welcome. Did you hear the question?
I did, Commissioner Robbins. Thank you very much. Apologies for the background. I'm a bit mobile today. Can you hear me okay?
Yes, we can.
Excellent. I have been listening to this entire hearing in all of its instances, and CDPHE did consult. Just as an introduction, I am Tessa Sorensen, Energy Liaison for CDPHE. I did perform the consultation for the GMT Gorge on this on behalf of CDPHE. In many of these cases, we do see ozone season and wildlife kind of butt heads. A lot of times, it really comes down to proximity to people. In this particular instance, I would point, and I can't buy computer since I'm not on it at the moment, to the 1 mile buffer map. That is a particularly useful tool that actually APCD does require in all of our permitting as well, which shows how much is actually near the facility. In this case, it's not much in that 1 mile buffer. So one of the things about these rules and their reference to a DI community is proximity to people, as well as the ozone non-attainment area. So if all things were equal, I would say that wildlife would win if you balance the scales for those two, simply because of proximity to people versus wildlife, because there's not a lot of people in that 1 mile radius buffer. That said, NOx intensity is definitely a concern. I think that overall NOx intensity is not on a case-by-case basis in terms of locations. It is on an operator basis. And so it's important for the operator to have the flexibility to adapt however they want or can to comply with those rules, which is kind of written into the SBP, the Statement of Basis of Purpose for AQCC's Reg 7 rules, which give a menu, as it were, of engine standard options that can be used for these things. So from CDPHE's perspective, and we do notice that there are multiple occupations for multiple pads. We also note that there are not a lot of folks within 1 mile of the locations. I think that's the key piece that helps us to inform our consultations and what we are looking at. Did that answer your questions, commissioners?
Commissioner Oath?
Yes, I appreciate that very much. And certainly am interested in the thoughts about proximity versus this being an ozone and a regional issue, not a proximity to particular RBUs, and this being an ozone season question. But yes, it has answered my questions. Thank you.
Thank you, commissioners.
Thank you very much for listening in and being with us. All right, commissioners. I think we've got, if my straw poll is correct, if we don't do anything further, we've got 3 leaning yes with the additional COA, which may or may not add a lot of value to it, but doesn't hurt. I think I've got 2 commissioners leaning no. Does anybody want to lean in a different fashion, or should I call for a vote? Commissioner Messner?
Thanks, Mr. Chair. I'm not going to lean in a different way, but a little more color after hearing the consultation or from the folks that provide consultations to us, and I really do appreciate that. But, you know, ultimately in an application, the operator has the burden of proof and, you know, presents an application and a plan before us, and we make a determination on that plan based on the evidence, on the testimony on the record and the application. And, you know, I continue to think that maybe not enough work has been done, you know, in fully exploring different options to determine whether it is reasonably possible to comply. And so I'll stay with where I'm at, understanding that at the last minute here, there was lots of things that were thrown around and considered, but ultimately the applicant does have the burden of proof to have already done this before coming to us and providing evidence and testimony that they've fully evaluated a reasonable effort to comply with the rules. And so they've provided a practicability assessment in lieu of that, and I appreciate that, but I'll stay where I'm at. So thank you.
You're muted, Mr. Chair.
Thank you. I'm not seeing anything further from a deliberations perspective. Pedro, if you could visualize yourself, do you have you captured the COAs that have been offered, and or do you need some time to talk with staff about that?
I would like some time to speak with staff, but I'd also like to make sure I've got the COAs that we're talking about. When we came back from our last break, GMT proposed a COA that GMT will use Tier 4 during ozone season and will immediately convert to Tier 4 rig. Will immediately convert the Tier 4 rig to electric if the electric grid becomes available during ozone season for the first occupation on the North Rim location. So assuming that we're moving forward with 3 in favor and 2 opposed. I believe that means we're still going to include that COA. Is that correct?
That's my perspective.
Okay, so I've got that one. There's also a COA that we discussed both today and I think 2 weeks ago regarding an updated consultation with CPW, as CPW's initial consultation did not reflect the exact same operating schedule proposed by GMT during this hearing. Is that still part of this, correct?
Commissioner Ackerman?
Yeah, Mr. Chair, given the fact that we extended this hearing to another day and that Mr. Moret was able to attend that hearing and given his comments, absent his objection on screen here, I believe the consultation has taken place that was needed, which was to clear up the discrepancy between what was in CPW's consultative materials and the presentation between the operator. I don't know that that COA is needed any longer since I think the extended hearings have fulfilled its purpose.
All right. Get that, Mr. Boudreau?
Yes, thank you for that clarification. And I believe we also still have a variance request for 1003B interim reclamation with the conditions of approval associated with that documented on pages 7 and 8 of the director's recommendation. That's still an issue that needs to be resolved. Is that right? I guess I'm asking Ms. Jost.
Thank you, Council. Yeah, GMT agrees to all of those conditions of approval, so we would just request that they be approved along with any approval of the OGDP.
Okay. So that being the case, I would ask for, let's say, 10 minutes to consult with staff to make sure we to go through the language on GMT's proposed COA and make sure they're comfortable with it, and then I can come back with a proposed motion, which will probably be a motion to approve with some COA language reflecting GMT's commitment coming out of the break, and then also addressing the variance and the COAs associated with that.
All right, let's return it. 12:09.
Thank you.
All right, we're back, but we're waiting on our Attorney General to pop back into the screen, so let's give him another minute. We are back. AG Boudreau, did you have a chance to consolidate the thoughts?
I did, Mr. Chair. Thank you for the time. I worked with staff to come up with adjusted GMT's proposed COA language a little bit and included in the COA GMT's commitment to grid power for all subsequent operations at the North Rim pad and all drilling occupations at the Black Canyon pad. So if everyone's on board with that, I'm ready to make a recommendation for a motion.
I think we're ready for your recommendation.
Thank you. I'd recommend a motion to approve the GMT Gorge OGDP with the following condition of approval. The operator will use a Tier 4 powered drilling rig during the ozone season and will immediately convert the Tier 4 rig to electric power if the electric grid becomes available during the ozone season for the first occupation on the North Rim location. The operator will utilize grid power for all subsequent drilling operations on the North Rim pad and all drilling occupations at the Black Canyon pad. I would also recommend the motion include an approval of GMT's requested 1003B variance for interim reclamation with the conditions of approval associated with that variance request as documented at pages 7 and 8 of the director's recommendation.
All right, thank you very much. Further, well, I will make said motion. Do we have a second?
I'll second, Mr. Chair.
All right. With a motion and a second, we now have an opportunity for further discussions on the motion from commissioners, if any. All right, seeing none, hearings manager Thomas, if we could do a roll call, please.
Certainly. Commissioner Ackerman,
Yes.
Commissioner Cross,
Yes.
Commissioner Mesner,
No.
Commissioner Oath,
No.
Chair Robbins.
Yes.
Mr. Chair, that motion passes 3 votes to 2.
Thank you very much, hearings manager Thomas. And thank you to my fellow commissioners. I think if nothing else, this shows the deliberations here show a lot of thought and effort by all 5 commissioners. I appreciate all of the commissioners' thoughts as we proceeded through this today. Ms. Jost, thank you to you and your client for the time and the effort, and thanks once again to staff for all the work they've done as well. With that, at this time, we are done with the commission's business for the moment. We reconvene at 5 p.m. this evening to have a 511 hearing on the State Blanca West. That'll be a virtual meeting. If folks want to attend, please go to our website and zoom in for that. So I would move to adjourn the commission at this point.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? All right, we're adjourned. See you this evening, folks.